assuming we're all set, Jamie. I saw a message come across.
And yep, we are live.
Great, thank you very much. Well, everybody, welcome to the Juvenile Justice Reform Council meeting for today, July 20th, 2021. We have a jam-packed agenda today, so I want to just jump right into things. Very excited about all of the speakers. Before we get started, I just want to thank all of our speakers. We have a total of 6 individual speakers scheduled for today. We did our best to get a wide representative of everybody that we possibly could. I know a lot of people were suggesting people, and we did our best to accommodate all. We'll talk about that in new and old business. But for right now, we need to go ahead and approve the minutes. So if I can get a motion to approve the minutes from the last meeting.
I would make a motion to approve the minutes.
Thank you. Second?
Second.
Thank you, Jenny. And if there's no objections, we'll move forward with proof that they're approved. Any objections? Great. So with that, we're just going to go ahead and jump right into the agenda. As I said, we have a jam-packed agenda. We have representatives with individual experience. We have some of the national landscape, and then we have some recommendations out of Pennsylvania as well. So again, I want to thank everybody that took the time to join our call today. I will remind anybody in the audience, the live stream audience, if there's questions afterwards, we certainly can address them through our office, either from the policy side or from the media side. You can reach out to our office. So with that, I'm going to go ahead and start with our presentation with Reginald Betts, if he is on the line. Can I see you over there, Reginald?
Yeah, I'm on the line. I think I was told I have 3 minutes, so I'll try to keep it brief.
Sounds great.
Actually, I think it's amazing to even contemplate keeping it brief when the subject is so important. But I'll frame it in 2 ways. When I was 16, I was incarcerated for carjacking. I'm from Maryland, but I was incarcerated in Virginia, and I spent 8.5 years in prison, including Sussex 1 State Prison, Red Onion State Prison, and several other prisons in Virginia. And as I came home after 8.5 years. I went to the University of Maryland, was a graduate. Went to Yale Law School. Now I'm an attorney, and as a public defender or working in a public defender's office right after law school, I represented young people who were being tried as adults. And over the past few years, I've been representing people I did time with who going up for parole or going up for clemency or in some way trying to challenge that sentence and get released. And one of the things I find challenging about this conversation is that it's always too brief. You always ask to sort of signal the parade of horrors that you've experienced or that you've seen, and it's never the kind of tangible, deep, reflective thought that might actually move the conversation and change the perspective of legislators in such a way that the policies actually change. I find it strange, really, to think that, the substance of these conversations really rarely talk about the ways in which people have been ruined by prison. I think about several people in my family, several people I grew up with who went to prison as teenagers and who came out scarred. But I also think about the ways in which as people that I grew up with who had family members robbed, murdered, raped by young people, and they remain scarred over the 20 or 30-year period of time of incarceration. That it's not just the young people who end up in prison who get failed, but it's the community at large who gets failed. And part of that is because there is frankly little expectation that young people could be beyond what they were in whatever moment of crisis they found themselves in that led to incarceration. Since I only had 3 minutes to talk, I'll say this one final thing. I've been talking about what it meant to go to prison as a juvenile since basically 2-3 weeks after I've been released. And in having this conversation, one of the suggestions was that I should look at some talking points. But the idea that I could fit the way in which incarceration, in my own incarceration, and the felony convictions that I have followed me my entire life with no reprieve, no matter what I do, in 3 minutes is absurd. And I like to think that, as somebody who grew up in Maryland, went to elementary school, middle school, high school, and college in Maryland. I have something to say about this because I'm a citizen of the state. But really, the reason I have something to say about it is because I know so much about others like me that were ill served by the system in Maryland, where young people will get a 30, 40, 50-year sentence that have no possibility of release. And then when the laws get changed, I ask why they were running around hopeless in prison over the 20 years in which the laws suggested that they would never have a opportunity for freedom. I know I've gone 35 seconds over my time, but I like to think that of those 3,500 days that I spent in prison, um, when I could have easily been somewhere else, when somebody could have easily expected me to have the potential of being a Yale law graduate, um, that they could have saved me some of that time too. And I just think about all of the young people who nobody cares about saving their time right now, while I am pressed to say the next speaker his time to be respectful. So I apologize for going over, but I do think that this is a kind of issue that's far more pressing than anybody could pretend to cover in 4 minutes. And I'll just say the first poem I read in prison was by Etheridge Knight. It was called For Freckle-Faced Gerald. The first line, the second cup stanza, 16 years hadn't done a good job on his voice. It was a poem written in the 1970s about a 16-year-old who went to prison then and was raped in prison. I read that poem in solitary confinement. We pretend like we don't know about the systems that we send people in, but we know because it's been written about for at least a half a century. Thank you.
Thank you very much, Reginald. I really appreciate your the recognition of the time and for everything that you shared with us today. Mr. Singleton, Michael Singleton.
My name is Michael Singleton. I'm from Baltimore, Maryland. In 1999, I think, I caught an adult felony gun charge. It was my senior year of high school. I was going to Gilman School at the time. Found a gun, brought it home, showing my homeboys, made a mistake and shot him in his leg. He went to go report the gunshot wound. I woke up the police officers and detectives in my room. And I got brought downtown. And right around that time in Baltimore, they were instituting this gun court. And now with the gun court, everything that was, it was immediately an adult charge. I was 17 years old. And I went through that whole process. I got it dropped back down to juvenile. I ended up going away to college and coming back. When I went away to college, I was on probation. I came back when I was 18 and expunged my record. And I've told that story a lot over the years. And I think the thing that stands out to me the most about that is that the only thing that really saved me from that was the fact that I had my pops with me. My dad was an attorney in the city of Baltimore for a really long time. So he was able to walk me through that process. Everything that was happening to me, I had somebody beside me that was going to walk me through the process and help me understand everything that was going on with me. When I was going up to court dates, judges knew who my dad was. So when I sit back and think about that, without him being in that situation, and I have homeboys who I went to school with who got caught up, not necessarily with accidental shootings, but they got caught up with felonies when they were juveniles and got tried as adults. The situation didn't go that way for them. Those felonies, like the previous speaker talked about, followed them for the entirety of their lives. And some of them aren't here anymore. And I think part of the reason they died so early is because they got put into the system that they couldn't get out of. You know, you get caught with the felony. One of my homeboys got caught with a felony when he was in college. He got put out of school for that. So now he just back on the streets, hustling, selling drugs, doing what he did to get the felony. And, in 2005, I buried him. So going through that process as a juvenile is terrifying. Going through that process as a juvenile without any support is terrifying. And then what you start to realize is that it's a lot of kids that get caught up in these situations that it could go a couple different ways for them. And it has nothing to do necessarily with the crime that they committed. It has to do with the availability of resources they have access to. So if you can access these resources, the justice system treats you completely differently. And I just had access to those resources. And those resources are the reason why now I don't have a felony. I can purchase firearms. I don't have to say I'm a felon, even though I had to plead guilty to a felony as a juvenile. Had I not been able to have my dad get me a lawyer and tell me what I needed to say when I was going through my psychological hearings, my whole life would have been different. And I think that that's part of the story that we don't really talk about. We talk about the kids who get caught up in this. We don't talk about actually the individuals that get caught up in this and the situations they come from and the things they have access to, not even before they do the crime, but like as they're going through the process, that they just don't have a lot of support. And now when they go through that and they don't have the support, now they fucked essentially, you know, and it's something that can be prevented in the beginning by not charging them as a juvenile. I mean, not charging juveniles as adults, but then realizing that once this child goes through this adult system without a lot of backup, a lot of support, they get jammed up in the end. And I'm very, very lucky to have that situation happen to me, and to be able to look back and see that my dad kind of saved my life. And without him being in my life and me being the kid that I was, going to a private school, having a family that I had, my whole life would have been different. And I could have made it, just like the guy who went to Yale Law School and now is a lawyer, but the majority of the people don't make it. They don't have that story. That's like a 1 in a million story. And if we want better stories, we got to change the system that these kids are coming through.
Thank you very much for you sharing your story. Ms. Blunt, Terry Blunt. I think you're still on mute, Ms. Blunt.
Okay, can
There
you hear
go.
me?
Yep.
Hello, everyone. My name is Terry Blunt. I'll be speaking of my son, Javon. Javon is a very driven and ambitious young man. He has a bright future. Unfortunately, right now, he is in an adult prison where he should be, learning new skills and starting a career right now. My son was still a child when they locked him up. On my very first time visiting him in prison, it was a 90-minute drive. And when we saw him, my sister had instinctively went to go hug him, and they cut the visitation and they canceled it. So we saw him for about 5 minutes. Javon wants to be an entrepreneur. He has so many goals, including owning his own business. Javon has always been a good student. He started off in a talented and gifted program, always got good grades. It was 19, I was 19 when I had him. So, naturally it was financial struggles. He always wanted to help out with the family. So he put a lot of pressure on himself to, go make money. He worked at places like Wendy's and McDonald's just to help out. Javon loved his family. He helped me out tremendously with my younger son, picking him up from school and, watching him until I got off of work. In high school, Javon fell behind in grades, making teenage mistakes. But while there, he met an assistant principal who he formed a bond with. She supported him to the fullest. She came and testified in his court case. Working with her, he did extra credit. He stayed after school. He did summer classes just so that he could graduate with his graduating class. And that's just what Javon did. After graduating, he kept striving to be independent. He enrolled and completed a real estate course, but still he was in prison as an adult. When my son was arrested, he had never been in trouble with the law before. As I later found out, he was dealing marijuana to make extra money. Javon made a very big mistake. He is absolutely sorry that a life was lost, but he also was the victim of a crime. While he was selling marijuana, there were 3 older men that tried to rob him of his car at gunpoint. He fired at the one who was holding a gun to his head. It was self-defense, but not in the eyes of the law. The state even prosecuted the 3 men for robbing him, but Javon is now in an adult prison. If those men never robbed him, he probably would be in a juvenile court for just a drug charge. It's awful to see my son in an adult prison. When he gets a chance to call me, he talks about how, especially for the last year, they've been locked down for 23 hours and out 1 hour. I always think about what goes on there and what he has to go through. I don't even think he would even tell me if something was to happen to him. It was in a, if he was in the juvenile court system, he probably could have been taking college courses or pursuing his real estate career. He could have gotten counseling to deal with everything that has been going on or everything that he has been going through. He has no access to any of this in the adult prison. My son doesn't belong there, and I wish I could just hug him again. Thank you for having me.
Thank you, Ms. Blunt, for sharing your story as well. Are there any questions for our first set of panelists with the individual experience, Mr. Betts, Mr. Singleton, or Ms. Blunt?
Nope.
Ms. Egan?
Yeah, I have questions, and this is a question for all three of you or whoever wanted to take it. Given your experience with this practice and given the outlier that Maryland is in terms of the numbers, how different do you think your experience would be if the case had simply started in juvenile court? And how and why do you think it's important for this law to change now?
I think for me, and this is a term that it's like something that people talk about now a lot, trauma. And it's not something that I really thought about at that time. And it took me a long time to think about it now, but it was like, yo, it's traumatic to go through all that. Like, I'm leaving school, going to Wabash District Court. I'm lying to my teachers because my teachers, if they find out, Gilman gonna put me out. The first state's attorney I had that was on the case after one of my court hearings, caught me in the hallway and was like, yo, I know you a good kid. I know you come from a good family, but I'm gonna try to put your ass under the jail. Like, I'm 17 years old, so I think that, and then you have to do all this fighting to now get it dropped back down to a juvenile court case. You know what I'm saying? So one, it's just the mental strain of thinking that, like, damn, I might go to an adult prison. I'm down in my basement lifting weights. I'm trying to prepare myself because at this time it was like, it was possession of a firearm was an automatic 5 years. So the only chance that I had was to get it dropped down to juvenile court, because if it stayed in adult court, it was no rap. I mean, I had the gun. So it was like, I was going to adult jail. So I think the trauma of that, having to carry the weight of like, damn, I might be going to an adult prison. I'm trying to navigate my regular life. I still going to court cases. I still got to take time out of my day to go get these psychological hearings, people showing up to my house, it just took a strain on me. And then it's just the shame of like, damn, like, I got caught up, like, how my family looking at me, how my friends looking at me. Am I going to be able to like get a job? Am I still going to be able to like do the things that I wanted to do in my regular life? So I think it was just an overall traumatic experience. I don't think at the time I thought about it that way. I was just trying to get through it and trying to basically not go to jail, try to maintain the semblance of life that I had before I caught the charge. But now when I look back at it, I think that was the biggest thing. And then when I now interact with kids in my neighborhood, friends of friends who are going through that same process, and you wondering why they popping pills and listening to the music they listening to and doing the drugs and just living the life that they live in, it's like, yo, they holding a lot. They dealing with a lot of stuff. Like the weight of having these charges, you can normalize it, because people around you have done the same thing. But at the end of the day, it's not normal, and it's not a responsibility that I feel like a child should have to bear. We keep all these other adult things from children. You don't let them do adult things, but then you hit them with adult charges. And it's like, well, you're not letting them drink. You're not letting them drive. You're not letting them vote, but now they're suitable enough to get hit with this charge. The reason why you don't give them adult shit is because they kids. and they can't deal with the strain of adult things. But now when it comes down to an adult charge, then it's like, oh, they can handle that, they can hold that, and that can affect the rest of their lives. So I think that's what it is. It's like that, this shit is traumatic. You know, they going through a lot, having to deal with that and having to fight it. And then God knows if you don't have nobody to help you fight it, then you cook.
Thank you, Mr. Singleton. Mr. Betts or Ms. Blunt, did you want to respond?
I did. I just wanted to piggyback off of what he was saying. It's definitely a mental thing for my son. I really feel like with him being, because he's been incarcerated for a year and some months now. But one thing that I always tell him is to stay mind strong, because it, you know, like he said, it's traumatic. It's a traumatic thing that happened. Even with the whole incident of why he's there in prison, it was traumatic. So the fact that he doesn't have any type of counseling or anything to get through what he did go through prior to prison, yeah, it's definitely mental.
Great, thank you very much. I don't see Mr. Betts on anymore. Mr. Betts, am I missing you? No? If not, I think Scott had a question.
Thank you very much. Mr. Singleton, I was trying to write some things down. I might have misunderstood. First of all, I'm glad that you're doing well now. But Mr. Singleton, you were 17. There was a gun charge and a shooting, and you did stay in juvenile court, and that record has now been expunged. Is that correct?
I got charged as an adult, and then through hearings, I got it kicked down in juvenile court.
Okay, I misunderstood. So you were charged as an adult, but it got waived back.
Right. So the commissioner charged me as an adult, and then I had to go, and I had to basically prove that I was a juvenile. So I had to sit down and do psychological tests. A person had to come out to my house, interview me with my family, talk to me about everything that was happening. And then they decided that it would get kicked down in juvenile court, and I would see a master instead of a judge.
Okay, thank you. I misunderstood the beginning. And Ms. Blunt, again, I'm sorry for what you're going through. May I ask what part of the state you live in that your son was convicted?
Yes, we are in Prince George's County, Maryland, and I believe it was Glenarden where he got arrested. Well, they went and got him in school, so he was at Bowie High School at the time.
Okay. Yes. Thank you so much. That's all I had, Glenn.
Great, thank you. Any other questions for our panelists?
I just had one question. Ms. Blunt, your son, what was his ultimate sentence?
They gave him 6 years.
I just wanted to note that for the record, that it's likely that he will be released while he is still in his early 20s. Is that correct?
Yes.
Thank you.
Great, any other questions? Seeing none, again, I'd like to thank all three of our panelists for presenting and sharing your stories and helping us collect more knowledge about this. So thank you very much. With that, we're going to move on to the two presenters that we have from the national landscape. First, we'll be hearing from the Sentencing Project and then the Council on Criminal Justice. So we can go ahead and start with Marcy from the Sentencing Project. Marcy, I think you're on mute.
Yep, and I'm trying to share my screen, so trying to do too many things at once. Thank you for turning this over to me.
Yeah.
I want to thank this commission because I know you guys have done a lot of work on this last year and during COVID when it was particularly hard to do this work. And, you know, I think that the recommendations you made last year are really, really important. We look forward to supporting them. Hopefully they'll come to fruition this year in the legislature. But I'm even more heartened that you're actually getting to a part of the work that was tabled last year. I've been at the Sentencing Project only since January, but I've been working on this issue since 2014. And Maryland has certainly been a state that has always raised concerns for us in its treatment of children as adults. So as somebody at the national level, I think it's really important that I contextualize. Everyone uses different language for these pieces, but I want to contextualize the number of ways that states have come up with to send children under the age of 18 into the adult criminal justice system. All three branches of government have the authority, not in every state, but across states, to send children to adult court. Many have multiple pathways, right? So judicial waiver is in 45 states. That's obviously grounded in the judiciary. That gives judges the opportunity to review a hearing. There is different levels of judicial waiver. Some of it is presumptive and other of it is mandatory. It is the most expedient and cost efficient pathway into the adult court. It is also used the least frequently. So even though the largest number of states have this as an option, it is used least frequently in terms of kids getting into the adult court. Number two is statutory exclusion. This is through the legislative branch of government. This means that the state legislature has decided at what age and what charges children will have their cases originate in adult court. Sometimes lawyers and advocates refer to that as direct file. We also call that automatic transfer because it's automatic, there's no hearing. There are 26 states that have that currently. The third is prosecutorial discretion. That is the prosecutor has full authority to determine which court children are charged in. It's also called concurrent jurisdiction. There are now 13 states that allow the prosecutor to determine which court a child is tried in. Jurisdictional boundaries, we've had a lot of success with this one. You might have heard of Raise the Age campaigns. This is when states establish the age of criminal responsibility below age 18. We are down to only 3 states that do that. And then the last way that we get kids in the adult system is these once an adult, always an adult law. 35 states utilize that. And what that basically means is once you're charged, some states say charged or sentenced as an adult, any subsequent charge will also be in the adult court, okay? I have highlighted in blue the options that Maryland currently utilizes. So you guys have 3 pathways. And I wanna say in moving forward, because I know you guys have reverse waiver and other places call waiver the process to get kids from juvenile to adult. You guys use it the other way. But today I'm really going to be focused on what we call automatic transfer, which is really just statutory exclusion and prosecutorial discretion. Is that about as clear as mud for everyone? Yeah, okay. It's complicated. And Melissa, you can jump in here if you need to clarify, help me clarify anything.
Hey, you're doing well.
The second chart here is really about what the trends have been. And we have had 26 states over the past 15 years change their automatic transfer statutes, right? And so if you can look at this map, everywhere in red has had one, if not more, changes to their laws. This is, as you can see, you know, it's not geographically isolated. It is not divided by red state or blue state. It's not divided by rural state or urban state. It really is based on a couple things. It is based on what we have learned on adolescent development, on neuroscience, what jurisprudence has told us. And it is also based on really good data in terms of effective interventions with young people who engage in delinquent and or serious criminal behavior. I also want to say here that, well, I'll save that to the next one. Okay, so how did those states get, what were kind of the policies that states used to paint that map red? One thing that states have done is they have struck one or more of those pathways into adult court, right? So they've taken one of those things off of the table, whether it's whether it's prosecutor discretion or statutory exclusion, or some of the mandatory waiver provisions. I'm going to highlight here Kentucky, because Kentucky just this year got rid of its mandatory transfer statute, and now it is one of only 8 states in the country that requires a juvenile hearing before a young person can go up to the adult court. I also want to point out Florida, right? I want to point out Florida because it had all of those mechanisms that I put on that first page. It got rid of its statutory exclusion. It got rid of that in 2018. California California is leading the country in this. They got rid of their prosecutorial discretion. And they have also done several other amendments that will come up here later, but they right now have the strongest law in terms of following best practice in the country. The second option is to raise the floor. And what we mean by that, I think what we mean by that, it's also called raising the age, but it's raising the lower age, right? So excluding the youngest children from eligibility to be transferred, right? In Maryland, your statutory exclusion of only applies to older teens. Your judges, however, have broader authority for that for capital offenses. There are about half the states that have no minimum age in which certain children can be charged as adults. And so you can see here that there has been, about a quarter of the states that have stopped sending children to adult court altogether based on their age. Again, I'm going to highlight California there because they don't allow anyone under the age of 16 ever to be transferred into the adult system. But many of these other states are hovering around, hovering around 15. Except for a very narrow number of charges. The third thing is that states have narrowed what charges are eligible to be sent to adult court. Again, Maryland, I have to say, is an outlier in this. You guys have 32 eligible charges. That is definitely at the broad end. Nationally, most states focus on what they refer to as the 7 deadlies, right? But there are still states that use drug offenses and some property offenses as well. But narrowing those charges is another way that states have tackled this. Fourth, we've had states that have expanded the reverse waiver or reverse back, right? So if a child automatically, this is kind of what we call a mitigating reform. If a child starts in adult court based on their charge, there are options to remove children back to juvenile court. Obviously, Maryland uses that quite a bit. I believe you use that as much as 60% of the time. And then the last thing is eliminate or restrict once an adult, always an adult provision. So Virginia and Washington State now require that the child has a sentence and that sentence would have been excluded from juvenile court, right? Because a lot of times what happens is children plead to something less, but there's still that lesser charge is still an adult charge. Okay. You all still with me? Okay. Thanks for the thumbs up. Okay, so one thing I want to talk about, states have shrunk their use of automatic transfer from about 10,000 a year to under 6,000 per year, and those were 2015 numbers. Melissa's helping me get more recent numbers than that. But I do want to say that those numbers are still double what we have in terms of judges sending kids up, right? So again, to the point that we are using this automatic where there is no hearing twice as often, at least, that we are sending kids up to adult court using a judicial hearing. Secondly, I want to say that the youth justice system has the skills, the staff, and the knowledge to handle these children, right? This is the Juvenile Justice Reform Commission. We know that young people make mistakes. Some of them are and engage in delinquent behavior. Some of them are serious, right? But the youth justice system was designed with a focus on rehabilitation, with the understanding that young people with supports do change and age out of crime. And they do have a continuum of care that can appropriately respond to every child that comes in contact with the legal system. Third, the part with automatic transfer is that we focus on the charge, and we know that charges do not drive dangerousness or risk to public safety. We've got to look at the whole child. Again, this is best practice. It's been supported by research. And that is, again, one of the primary reasons that we established a separate juvenile court to begin with. Automatic transfer also drives racial and ethnic disparities, which are, you guys have done a lot of work on this, so I won't go over that, re-drive home the numbers here, but I want to say that that point of transfer and sentencing children as adults is incredibly disparate. And we have got, nearly 90% of children sentenced to adult time are children of color. This falls very heavily on Black and brown children, despite the fact that children engage in criminal behavior roughly at the same amounts across race and ethnicity. Next, children in the justice system, return them, it exacerbates trauma and recidivism. I want to call to our earlier, both Michael and Dwayne and Ms. Blunt talked about this. There is lasting impacts. When kids go to the adult system, we actually have 2 federal laws in place now because the abuses are so severe against children in adult systems that there's been a real big push to get them out of adult facilities. There is incredible trauma and victimization that happens there. And if our goal is on rehabilitation and public safety, we should be supporting approaches that get us there. There are 9 states who send children, more than 200 children, to the adult system every year. That's actually much lower than it used to be. But Maryland is one of those 9 systems. I also do want to point out, Jenny had pointed to earlier a 6-year sentence that Ms. Blunt's son got. I do want folks to realize that I think a lot of what drove the move to automatic transfer was the temporary spike in crime in the 1990s, where we all feared that children were beyond rehabilitation, that they were super predators, all of these very damaging imagery. That was very quickly proven to be false. And I want to say that this harsh punishment, you do the crime, you do the time, is also proven to be very false in terms of this practice. 85% of children who are charged as adults are home by the time they're 21. That is the age of extended jurisdiction of juvenile court, and certainly it is in Maryland, which means the juvenile justice system could have handled them. 95% are home by the time they're 25, right? So we got to remember that the juvenile system really is the appropriate place for many of our young people. Okay, so national rates of transfer. I have had advocates all over the country asking me for this. It is very hard. Maryland actually does a good job publishing your data. There are a lot of states that this data is very, very hard to find. But we were able to look at the transfer, not only the numbers, the raw numbers of young people, but the rates of transfer. And as you can see, Maryland is second only to Alabama. I do want to point out that these Alabama numbers are from 2016, so they're about 5 years old, but they're a state that doesn't publish it. I have to actually, it's beyond FOIA, I actually have to make a court appearance in order to get that data released to me. But I also want to point to Florida here. Florida used to be ahead of Maryland. They, however, as I referred to earlier, changed their laws. They have now dropped to 4th place. I know that Representative Zabel will talk later, but Pennsylvania is also working on this. Their numbers have dropped based on prosecutorial changes in practice, and they are now looking, and because those changes in practice has yielded good outcomes, there is also more work going to be done there. I also want to point out some of the other states. Look at the low numbers here: Texas, Colorado, California. Texas has had very moderate changes to their laws, but they are one of those states that requires a full judicial hearing before a child can be transferred up to the adult court. Colorado and California both had major reforms that have led to these drops, right? California last year sent 25 kids in the entire state of California to the adult system.
Marcy, we're going to need to wrap up.
Okay.
Sorry, my friend.
Yep, no, that's okay. Last thing I will say is that please don't feel like I'm picking on prosecutors, but they are usually the people who argue the most against this. And I understand it feels like a tool, and tools getting restricted feels uncomfortable. However, I will say there's a lot of power in DAs to get educated and trained and change their practice around this. And here are three of some major prosecutors who do support limiting this and doing individual review. So I will turn it over to my friend, I know, Mark Levin, who has worked on more than half these states with me.
Great. Thank you very much, Marcy. Yep, I'll turn it right over to Mark. I saw Mark. I don't see him. Oh, there he is.
Oh, unmute. Okay, is that better?
Yep, now we can hear you. We can't see you, but we can hear you.
Oh, okay. Well, let me remedy that as well. But yes, I really appreciate the opportunity to be here. And it's a tough act to follow, the excellent speakers we've heard from already. But let me just say, I think it's important to remember that children aren't adults in terms of their brain development just because we say they are. And that kind of was the assumption behind many of these laws throughout the country in the 80s and 90s. Adult transfer laws really weren't anchored in research. They were in response to, I think some legitimate concerns about rising crime in the, late 80s and early 90s. But there was certainly, as we saw with the super predator kind of slogan, there was a lot of hysteria as well. And states across the country kind of leaped into these laws without doing a lot of research about whether prisons would actually be effective for children. And it turns out they're not. The other thing I think that's important to note is, we have better tools now to rehabilitate kids in the juvenile system. There's functional family therapy, cognitive behavioral therapy, and then we additionally have better tools to match the right individual with the right program, which is both the case in juvenile and adult, using, for example, risk needs assessment. And then at the end of, for example, an indeterminate sentence, which is typical in the juvenile system, we can use some of these assessments to better figure out whether it is time for that youth to be released from a juvenile facility, that they have met their goals in terms of rehabilitation. Their attitudes have changed. Many of these instruments look at whether they have antisocial, anti-authority attitudes, and you can actually monitor progress on that. And, we'll never have a crystal ball. Obviously, there's always going to be recidivism, but we are better able to, I think, prevent and measure that now than we had been. So I think, as you heard, many aspects of Maryland's adult transfer laws are out of step with not only the research, but longstanding practices even in other states, and certainly the trends in other states. Obviously, being second to Alabama, I think, isn't something someone would guess when it comes to this area. And I think certainly you could also break down some of the issues with your laws into two different columns in terms of mandatory transfer on the one hand and discretionary transfer on the other. The discretionary waiver by the Juvenile Court of Jurisdiction in Maryland is available for any offense by a defendant 15 years or older, which is really broad compared to a lot of states which, limit even discretionary transfer to serious offenses. So that's certainly a concern. And then, of course, the automatic law that excludes certain juveniles from adult court, even as young as 14, for those charged with a crime that would lead to a sentence of life imprisonment potentially. That's also, I think, extremely concerning. 14 is just incredibly young in terms of someone's development on critical faculties such as impulse control, judgment, and so forth. Again, you've seen big trends. I was involved in Colorado, for example, in 2012 when they reined in their similar direct file policy. And to the point earlier, it was over strenuous objections by prosecutors. But ultimately, there's many great prosecutors out there, others that may not be doing everything they need to in terms of things like preventing wrongful convictions. But the bottom line is it's up to policymakers to hear from everyone, including prosecutors and advocates and those directly impacted, as you have earlier today, and make the most objective decision that follows the research. And victims, I think that's an important point. And I don't think we know that victims necessarily prefer adult court. I think we know that victims most of all, want to make sure what happened to them doesn't happen to someone else. And if you actually look at the research, the juvenile system is more effective at that. There's the CDC actually looked at 6 different studies, and for example, on Florida youths that were sent to adult prisons, and there were 34% more rearrests than comparing those with similar criminal records that were kept in the juvenile system. Texas is actually a really interesting example, and of course that's where I'm from. In the most recent year, less than 50 adult certifications in a state of 28 million people. Now, there is a different sentencing regime that I think explains part of that, and that is a blended sentencing option for the most serious offenses. And that means, of course, that the youth would start out in the juvenile system, and then once they reach a certain age, they would be reviewed to see if they should either go to adult parole or to the adult prison system. Although Texas, our juvenile system has many problems, including physical and sexual abuse, I'm sad to say. But one of the few perhaps shining aspects of it is this Capital and Serious Violent Offenders Program, which is at the Giddings School in Giddings, Texas. And they incorporate restorative practices, including bringing victims in to talk with the kids. And they have had a 3.1% reincarceration rate 1 year after release, a 95% success rate over 3 years in preventing violent offenses. And I think what's significant about it is scholars like Michelle Deitch have compared similar use for homicide, for rape, I mean, really serious crimes that went into this Capital and Serious Violent Offenders Program at Giddings with those that went to adult prison, and found much lower recidivism in the former. And I think that's really illustrative of what the opportunity we have to do something that's not just, I think, more humane, but also better for public safety. I think that obviously the provision that's been referenced earlier on once an adult, always an adult, creates the consequence of where the next offense could be relatively minor and still be required to be handled in adult court. So I think it's important to change that as well. So in addition to recidivism, there's some other issues that are important, I think. We talked about the national research in terms of more likely to be physically and sexually abused in an adult facility, whether that's by another incarcerated person or staff. Solitary confinement is another example. In 2019, Maryland passed a law that limited solitary in juvenile facilities. Staff ratios are typically much lower in the juvenile system. The adult system is not set up typically to work with families, and the education system, visitation may be more limited. A lot of these youngsters need a high school diploma. It's so critical, and juvenile facilities are typically much better set up to provide that. Then, of course, as Dwayne indicated, the lifetime stigma of a criminal record has profound consequences in terms of subsequent opportunities to be admitted to higher ed institutions, to get financial aid, student loans. And then, of course, in terms of employment and housing, it's very difficult to rent an apartment when you have something on your record that's significant. And obviously in the juvenile system, you're able to, provided you're successful, get that off your record. So that is a major lifetime difference in terms of going into the juvenile system. Now, one of the concerns that's come up in some states, particularly is in regard to raise the age, has been juvenile capacity. But what we've seen in Maryland and across the country is the juvenile system is actually, because arrests are down and commitments are down, there's extra space. So in fact, in Maryland, you only have about half of kids locked up that you had in 2011 in the juvenile system, and 42% of the kids in confinement as of late 2020 were being held pending adult court action, the population we're talking about today. So I don't think there should be a concern in terms of that the juvenile system can't deal with these individuals. And to your credit, they are being held there pending trial. Some states, when kids are facing certification as adult, they're in adult jails, which is certainly much worse. So that changed several years ago in Maryland is certainly to be commended. I think that one of the other issues that was mentioned earlier, as much as I think mandatory transfer is of greatest concern because there's literally no way out, the having excessive discretion, such as I mentioned with the wide range of offenses for 15 and older, I think that has a tendency to exacerbate racial disparities. And I'm sure you're aware 81% of the adult transfers in Maryland are Black children. And so I think that obviously we respect the role of judges, but on the other hand, you're bound to get outcomes that can vary not just by race, but by county and other kind of extraneous factors when you have virtually unlimited discretion, such as by allowing any offense to result in transfer. So let me just conclude by also saying, as you look towards the future, I think, certainly the most realistic option is probably to move towards a system without mandatory transfers, but some discretionary transfer is probably where, there might be consensus for policymakers. And I think there, what you need to do is make sure there's the right guidance for courts, that they explicitly need to consider research on brain development, an individualized assessment of the youth's maturity and culpability, and definitely saying, taking into account the trauma they may have experienced, such as exposure to violence, whether within or outside the home or both. We've seen a tragic increase in domestic violence, of course, during COVID. We know there's many kids that grow up in neighborhoods where there's gunshots outside their home in the park. They feel like they have to join a gang to survive. And there was just a study by the Center for Court Innovation on young men carrying guns in New York City, which really laid that bare. And again, it's not to excuse criminal activity, and certainly not serious criminal activity, but it is to shed light on not just the factors that lead to that, which are, a combination of individual, culpability, but also the environment that someone was in, which had they been in a different environment may not have committed that crime. But it's also to shed light on the opportunity for change once placed in a different environment. And I think that's where that's one of the reasons you see these low recidivism rates for second look cases, because again, that may have been in the context of a kid trying to protect himself from a rival gang. And once you take those environmental factors away and administer some real evidence-based programming, it's perhaps not surprising that the recidivism is as low as it is. So I also think the court should be required to consider whether the youth has exhausted all services available in the juvenile system, and also the aforementioned collateral consequences. What we found in looking in some other states is that a number of youth do get certified or transferred to the adult system, even though they haven't had the types of programs I talked about earlier that can be very effective in the juvenile system. So I think that should be considered strongly by courts in making these discretionary decisions. So I'm really glad that y'all are taking this up, and I think significant progress has been made on other recommendations by the council last session, and I hope this discussion will lay the groundwork for the same on this topic in the upcoming Maryland session. So thanks again.
Great, thank you very much, Mark, and to Marcy for sharing your experiences with this. Are there any questions for Marcy or Mark? See you up there, Scott. Yep.
Thank you so much. And thank you to both of you for presenting. I just have to ask, and I'm sorry, I don't know how you say your last name, Marcy. What would you do with a 15-year-old who kills his father, his mother, his two brothers, is 6'2", 200 pounds, with a 125 IQ? What would you do with that person?
So I think one of the myths, or one of the reasons I open with that slide on the multiple ways that children get to the adult system, and what Mark was just referring to, is what we are saying is that you already have a process in place by which that case, and again, you didn't answer all of the pieces to the questions that Mark just posed very eloquently, but you answered some of them. But I think that there is a process by which a child would start in juvenile court, and there would be a juvenile court judge that would hear all of those facts of the case. Then they would make that determination based on a bunch of individual factors, and maybe they would make the decision to waive that child up to the adult court.
So
no one's suggesting taking that part away.
Okay, so what I hear you saying is that the aspect of Maryland law that permits people to waive them up, I don't want to put words in your mouth, but that's okay. It's the automatic start up and trying to wave back that you have a problem with. Is that kind of where I'm going?
That is that is the thing that I think drives the worst outcomes. Correct.
Okay.
You heard me correctly.
And then you mentioned 32, I think it's 33. Jenny, right? 33? 33.
Sorry.
That's okay. I'm sure we added one last year. And you also think we should examine that list of 33 and maybe squeeze it a little bit. Does that sound fairly reasonable?
If I could have I would get rid of your statutory exclusion, get rid of all of those and move them to juvenile court and let the judges decide on all 33 charges.
So theoretically, I could waive a 15-year-old up for a carjacking.
You already can.
I understand.
Yeah.
I just wouldn't start them out in adult court.
Correct. They would have a full benefit of review of a juvenile court hearing before that decision is made.
Okay.
Yeah, no, I think that.
Go ahead,
Go ahead.
Mr. Levin. Yes.
But I think both of you are asking some good questions and I think some valuable answers. I think the other thing we haven't mentioned that your comment reminded me of is that an increasing number of kids are being waved back by the adult court to the juvenile court. And so that's an inefficiency in terms of delaying justice. So that seems to be particularly in Baltimore County and some of the others where so in other words, that kids are starting out in adult court a lot of the time that actually end up in juvenile court, but that beginning in an adult court, especially for assault, some of the things, well short of homicide, what I'm talking about, that ends up delaying the progression of the case.
All right. Thank you both very much.
Any other questions? See Jenny? Yep.
We saw a presentation from DLS at our last meeting that showed that Maryland has waived a number of very young children to adult court, including 4 8-year-olds over in the last decade, and a number of 10, 11, and 12-year-olds are almost all Black are waived from juvenile to adult every year in Maryland. I was just wondering if either of you could comment on how many other kids under 13 are being moved to adult court in states like California, Florida, Pennsylvania, or any of the other comparators you use.
The only place I can say with absolute conviction that the number is 0 is California, because they don't allow it. I know that Pennsylvania had a couple children that got adult charges at 10, but I believe they ended up being sentenced in juvenile court. Representative Zabel, I would defer to you on that. It is a very small number, and I actually really would challenge us all to look at our moral compass on whether an 8-year-old really even understands what a charge would be in that case.
Yeah, I can tell you Texas, the minimum age for juvenile certification is 15. Of course, as I said earlier, we have the blended sentencing. But then in those instances, the kid starts out in a juvenile facility until they reach the age, which that's a challenging area because it was lowered. I don't know what your age in Maryland, how old you can be and stay in a juvenile facility. If it's 20, I think it might be 20, but I don't know what that is. But it's a tough call because, of course, there have been instances of older kids in juvenile facilities, abusing younger ones. But on the other hand, the continuity of programming and is important, and the juvenile facility can offer far more of that. But with the blended sentencing, once they do reach that certain age, then in Texas, the sentencing court then determines if they go on adult parole or to adult prison. So I think it's certainly that it's true we have less than 50 certifications a year in Texas, but that's partly because we do have that blended sentencing.
And Jenny, the only thing I would add to that is that there are programs, Mark talked earlier about programs that focus on family functional therapy, cognitive behavioral therapy. There are residential treatment programs that will take children with very serious offenses and take them into much more of a rehabilitative environment, that they're working on the trauma. I don't think anyone I think if you look at the cases surrounding an 8, 9, 10, 11-year-old that is charged as an adult, there probably is some significant family trauma going on, but there are places that are willing to take them and actually work on rehabilitation, not only with them, but in the family, in the context of their families.
And Jenny, I don't want to give you a heart attack, but even I don't think an 8-year-old belongs in adult court.
Pennsylvania once did have a 9-year-old convicted in criminal court and was transferred back to juvenile for disposition. But because the prison system doesn't know what to do with a 9-year-old, not even close. So, I mean, Jordan Bound's probably the case that comes to mind more recently. I think he was 11, bounced back and forth before they figured out what to do. And then it ends up, oh, wasn't him after all.
Any other questions for Marcy or Mark? I'm not seeing your hand. Just go ahead and start asking it. Nate, was that a question? I saw a movement towards the screen.
No, I'll wait.
I was pointing to Senator Carter.
Oh, okay. Thanks for pointing, Nate. Senator Carter.
Mr. Chairman. I'm sorry. I realized my question really wasn't regarding the subject, but it really wasn't to either of them. So I was going to wait.
Okay, great. Okay, great.
To Betsy, or maybe anyone can answer it. So along the lines of these programs that are designed in the juvenile system to meet the children's needs and the continuity of programming, I was taking a look at the court case that came out this week. Well, I think it was this week or recently, where the courts are to consider the specificity of the programs available to meet the children's needs. At least that's the way I read it. And so I was wondering if you don't have to give us a whole elaborate dissertation about the programs available now, but and we may have had it at some point, but if we can have some assurance that there are those programs available to meet the needs of these children right here in Maryland. And I'm sure that you have a list of them.
We do. We have a great resource on our website that I can make sure gets out to the council members. But DJS is always refining our continuum. We're always looking at newer programs to meet the needs of the kids that are coming into our system, whether that's through the juvenile court or because they were transferred back from the adult system. And with so many kids transferring back from the adult system, we have really developed a continuum that meets those needs. And so I can definitely make sure that you have access to all those programs. It's a pretty detailed list of what youth they serve, what behavioral health interventions, what substance use interventions are provided, what educational supports are provided. And so we can make that available, but it has evolved, I would say, over the past decade to meet the demand of young people who have been transferred back, since most of them are coming back to the juvenile system.
That's it. I mean, we can look at a list, but it was more just giving assurance to this group and to the public to have the availability of programs to meet the needs of these young people in the system. And that, there's not something, that could happen where the court could say, well, we cannot deal with this child in the juvenile system because there's nothing that we have available to meet this child's needs. So that was more what.
We have not encountered a youth that we were unable to serve. And if we don't have an actual program right in our continuum right now, then we need to go find that continuum if we have a kid that comes in with a need that we may not have the best fit for. And we've done that. So I mean, yes, with every kid who's come through our system, young person, sorry, I shouldn't use kid, every young person who's coming into our system, we're able to serve, whether that's this young person coming through the juvenile system or because they started in the adult system and then came back to our system, we're able to serve all kids.
Just in the interest of time, I heard someone else mention Mr. Chair. I don't respond well to that. Glenn is a lot easier, but I see their hand. Yep.
I just wanted to, as a point of personal privilege, thank Ms. Mistret and extend my regards to Mark Maurer, and also to thank Mark Levin, who's been exceedingly helpful during session under really rough time constraints when we've wanted the views of Right on Crime. So thank you very much, both of you.
Thank you very much. In the interest of time, we're going to go ahead and keep moving forward. I want to thank you both for, again, sharing your expertise with us. Moving right over into Representative Mike Zabel from Pennsylvania. He's co-chair of the Pennsylvania Juvenile Justice Task Force. Floor is yours, sir.
Thank you very much. Do you happen to have, I just want to make sure, do you have the slides I sent over by any chance?
We do. Would you,
Okay,
I
great.
can open those up and run through those, or you can also do a share screen if that's easier.
If you wouldn't,
Sure.
if you wouldn't mind running through them as we get started. It is good to know, by the way, I've served as the chair of the Pennsylvania Juvenile Justice Task Force, and I've sat in and presided over many of these meetings where they run long. So I'm going to try to just give you a brief aerial view of what went on in Pennsylvania. We just finished a 16-month process that started in person right before COVID. And then once that hit, we moved largely virtual and spent several months digging into data, then listening to stakeholder feedback in all sorts of areas, and finally moving into debating individual areas of policy. So I know you'll have that, or have probably already begun debating that as policy. So I'm not here to tell you what to do so much as just give you a brief look at what we did. Because as you'll see, when Marcy was mentioning Pennsylvania is very much one of the states that needs to look at its practices and look at what juvenile justice should look like in 2021 as opposed to 1995. So if we can go to the next slide, we can probably skip over the first 2 or 3 here. Yeah, this is just mission statement stuff. Let's move to the first. If you say, those are some of our task force members. You can see they covered a bunch of areas. Here's what I want to talk about, the key data findings, because as I understand it, I wanted to hear a little bit about what we're going to do with adult prosecutions. Just so you know, in our phase, we just issued our final report and policy recommendations. And we are now entering the legislative process where we are drafting legislation, and there's going to be more pull and push with that, as I'm sure you're all very familiar with. Pennsylvania is a very politically diverse and regionally, geographically diverse state, and there's a lot of different mentalities and mindsets towards criminal justice. But what we've tried to do as a task force is stick to data rather than relying on sort of instincts and guts and slogans and saying, what does the data show works and what doesn't? So you can see from Pennsylvania followed the nationwide trend in 1995. They instituted what you've been talking about, statutory exclusion or direct file. Pennsylvania is one of the states that hasn't modified that at all. And of course, any felony in Pennsylvania against a child 14 or older can be transferred by the juvenile court for criminal prosecution. So here's the single biggest thing we looked at, or what we found in the data. Charging a youth in the adult criminal justice system doesn't do generally what we want it to do. It potentially serves the interests of community safety, incapacitation, but it does not serve as a deterrent. And in fact, frequently leads to higher rates of offending, recidivism, and frankly, escalation of the type of offenses that you'll see from an offender. So a robbery, like a nonviolent robbery, which still might be prosecuted as an adult prosecution, might escalate typically once they start to enter into the adult system. And there's data that tracks that and shows that happens. You see the next slide, please. So Marcy mentioned that in Pennsylvania, direct files are down. That's true, but it's only really true in 2 counties, Philadelphia and Allegheny. Allegheny is where Pittsburgh is located. So it was really hinging on the personal preferences of 2 district attorneys in the 2 most urban counties in Pennsylvania. And we found this was a problem throughout our juvenile justice review, is that discretion was leading to disparate incomes, particularly when it came to racial equity. And that's true both with the direct file and adult prosecutions, but just generally when we would look at portions of the population. I think it was Marcy or Mark who might have said, youth generally, regardless of racial demographic, offend at the same rate. But what we were seeing was, for example, just about across every possible category, that Black boys were more likely to be referred to adult prosecution. They were more likely to be given carceral sentences. They are more likely to just simply being put into the juvenile court rather than being adjudicated. And part of that was, or part of what we concluded was that there was so much discretion being afforded that was what was giving birth to a lot of disparate incomes. And we took it upon ourselves to try to find what sort of recommendations can we put in place that are making sure that every kid is at the first look, while building some guide rails for community safety. How can we make sure that every kid is getting their best shot and the state is getting the outcomes that it wants as well? Can I see the next slide? So one thing we found in Pennsylvania is that in Pennsylvania, youth are more likely to come under criminal court jurisdiction due to statutory exclusion than transfer. Okay, so like you mentioned with waiver, for example, you can certainly waive up into adult court, and that happens. But direct file was driving that was driving that to a large degree. And you see that dip there that goes down in 2018. Again, that was largely due to drops in Philadelphia and Allegheny County. So there are 65 other counties in Pennsylvania, including mine, Delaware County. So the problem wasn't exactly going away. It was more flattening out, except for 2 pockets of Pennsylvania. And we, of course, are elected to represent the entire state. Next slide, please. The next thing we found in transfer hearings, juvenile court judges in Pennsylvania sent youth to adult court for criminal prosecution at least 70% of the time. So there was this heavy driving into the adult system, which created which in some cases, of course, we heard the hypothetical where theoretically adult prosecution would seem to fit, but not always ends. When you drive a child into adult prosecution, there are certain consequences to that. Negative consequences, regardless of whether a conviction is ever achieved. So next slide, please. Here are the most common offenses that were transferred to criminal court in Pennsylvania. This is not the direct file, so this wouldn't be, as Marcy would call it, the 7 deadly sins, what we would think of as some of the most offensive or violent offenses. But these are, and the most common one was possession with intent to deliver drugs. I was a prosecutor in Philadelphia. We called this PWID. It's just drug distribution. And that could be as simple as handing somebody some pills or running a drug dealing operation. And theft related offenses. This is not robbery, but simple theft. Firearm relation, often gun possession, and then a few others as well. So there were possessions that were being up there that, for example, possession and theft offenses that aren't necessarily violent, but are getting transferred to adult court in large numbers in Pennsylvania. Next slide, please. And then somebody mentioned, I think maybe Mark, about efficiency. What we saw was that when we do get adult prosecution, 60% of it either gets dismissed, withdrawn, or ends up in juvenile court. So the system wasn't quite working the way we wanted to from an efficiency standpoint, either recognizing that these adult prosecutions were getting sent back, or whether if it was a direct file or whatever else it was, that there was a judicial inefficiency at work as well. Next slide. And here was a major piece of data for us. Approximately 80% of the youth convicted in criminal court are sentenced to time in a county jail or state prison. And I could talk to you for 90 minutes, I'm sure Marcy or Mark could, and many experts could, about the effect of incarceration in an adult prison. The effect of that upon youth is, generally speaking, it encourages, or it's traumatic, oftentimes traumatic, and encourages recidivism. There is no, in 1995, I was only, I think, 16 years old, but that was, I think, around the idea, I think my parents thought it probably worked. The idea of scared straight or something like that just is not backed up by data. In fact, perhaps in a more instinctual common sense sort of way, if you put a 16-year-old into a general prison population with 25-year-olds who have been convicted of violent offenses, and they've been referred there for an adult possession with intent to distribute charge, that exposure is not going to rehabilitate them or anything close to it, but it will, in fact, more likely draw them into escalating recidivist behavior. So this was a concern of ours. And you can see the average minimum confinement sentence was 28 months. That's the minimum there. So 2.5 years, or almost 2.5 year minimum sentence. That's just before they can become eligible for parole. Next slide, please. So I kind of brushed over that. We spent a lot more time on this data, and I could get into it much more granular with you. Happy to discuss that, by the way, individually with any of you if you ever want. I'll make sure you have my email addresses. But here are our recommendations. And when I say, when we take a look at these, these were the product of great debate and compromise. There were people who I would say would prefer that it went further in terms of a reform direction. There are others who were very hesitant, but had to be persuaded by the data to move this far at all. But this is where we decided, looking at some of the same data that Marcy was presenting, that it made sense to eliminate statutory exclusion from juvenile court, eliminate direct file. And what we would hear, and that we had prosecutors on our task force, sometimes they would bring up a case like, for example, was heard earlier. And as a prosecutor myself, I would say generally those cases are going to wind up most likely, or a case like that, like one we heard today, but also I would expect most homicide cases, for example, to wind up in adult court anyway. But we thought it would be better policy in Pennsylvania if it were juvenile justices who deal with youth every day, making the decision about whether the youth and the state or the Commonwealth are best served with an adult prosecution or something going on in juvenile court. We also are going to raise the minimum age at which age youth can be transferred to criminal court for certain serious offenses to 16. And if you look at for certain serious offenses and say, well, what does that mean? That means we were negotiating it and we ran out of time before we could agree on what it was. So that's going to be settled in the legislative process. But the idea is to raise the minimum age for certain felonies. I would, for example, expect that possession with intent to distribute drugs will fall into one of these offenses that you can't transfer to someone before they're 16. Another thing we recommended to do is shifting the burden. In Pennsylvania, the waiver process, I don't know Maryland's law off the top, but you have to show, or the court must determine that the public interest is served by transferring the case to criminal court. But in some cases, in some instances, it is actually the burden right now in Pennsylvania. It's the youth's evidentiary burden to prove that it's in the public interest for him to be tried as a youth. That always seems to me just unfair, even as a former prosecutor. It seems to me that the Commonwealth should always have the burden as a matter of policy, but we think it will also be helpful in terms of making sure that it's not up to a youth and his potentially or her overworked public defender to make a case, but rather it is going to have to be the Commonwealth's burden to make the case to a judge as to why this should happen. And then this might be the most important of all the recommendations with regards, other than maybe eliminating direct file, which is that youth under the age of 18, our recommendation is they cannot be held in county jails, even if the youth is being charged as an adult, because we have seen and we saw that youth awaiting trial in adult court oftentimes are when they're in an adult system, they are in an adult prison system, and they are actively being harmed by being there, actively being harmed. Whether they're ultimately found guilty or not, nothing good is happening to them by keeping them there in adult prison while they are awaiting trial. We are not serving them. We are not serving the community. There are alternatives that can ensure community safety while also allowing for the possibility that at 16, it isn't the end of the road for you. And that was a big driver in terms of what we want to be able to do. Those are the large, sort of writ large findings we have with adult prosecution. So I won't go any further than there. I will mention, by the way, since the minimum age of jurisdiction came up here, in Pennsylvania, the minimum age of jurisdiction is 10, and our recommendations in our task force are to raise that to 13. And I'm certainly sympathetic to, I think, I was also a high school teacher before I was a prosecutor. And I'm certainly sympathetic to the arguments about 15 and 16 maybe even being a higher age. But this was, again, 13 was a number that we landed on based on a survey of national trends and where we thought we could get to as a politically diverse state. So I think that's my last one. Oh, there's a link to our report if you like to find it there, and my contact information is there. I'm happy to talk about it. It's been a long piece of work, and I think it's some of the most important work I've ever been a part of. I'm sure you're getting the same sense of the importance of that mission, because it's not just community safety and taxpayer dollars that you potentially could save, but it's also lives and children's lives, and the ability from what we know about the brains, the psychology of developing children, and that the moral center of your brain is arguably not finished according to brain science just until you're in your mid-20s, which I can personally attest to. I was still working that out. So that's a 30,000 foot view of what we're doing in Pennsylvania. I hope we're able to push it through. I wish you the best of luck on your mission. If I can ever be of any help to you, I tried as a co-chair to always give the devil's advocate side of the argument to make sure that we were coming at these from a perspective, a 180-degree perspective. So thank you very much. It's an honor to speak to you, and I wish you the best of luck with this.
Thank you very much, Representative Zabel. I can tell that you were the co-chair because you landed perfectly on your time that we allotted for you. So you've definitely been in this position before. So thank you very much. Are there any questions for the representative? Nate?
Yeah, thank you so much for that. I'm just curious if you could talk a little bit more, because it felt like the real crux of this issue here today for us about the idea that the Commonwealth has the burden, and what that conversation was like as you worked on this as a task force, because it seems to me that this is so much, especially as Mr. Schellenberger's questions were asking before, this is the crux of much of what we're talking about is, should we presume young people to be juveniles unless the Commonwealth or the state can make the case that they're not, that they somehow need to be treated differently? Your task force came to that conclusion. I'm curious what that conversation was like, because it feels like much of what we're really tackling right here.
Right, and you know, I have a close friend of mine is the Delaware County District Attorney, and we were talking through this. A good friend of mine, and community safety drives, I think, particularly with homicide cases, but let's say a home invasion or that sort of thing. I think that's going to be in the front of, just from a matter of practical experience, judges are going to look at that and go, community safety is the number one issue in that particular circumstance where they would be likely to be tried as an adult. So I understand that concern, but at the same time, and I was saying this in genuine good faith as a former prosecutor, violent offenses, extremely violent offenses would still be likely to be tried in adult court. But what would be cut down by getting rid of direct file are all of these sometimes discretionary or offenses that don't fit neatly, let me put it that way, that don't fit neatly into some sort of heinous crime. And the other problem, we can get really deep into it, but the felony murder rule can often mean that, let's say a 13-year-old is out with two other 13-year-olds, and they make an agreement that they're going to go in and steal some candy from I had a case like this when I was a prosecutor. They're going to steal some candy and some drinks from the local grocery store. And one kid is outside, he's the lookout, and the two go in, and I think it was the pharmacist gets fresh with this one kid. Pardon, I'm just trying to get to, and it escalates into violence, right? And this adult who's done nothing wrong gets shot, gets killed. That kid on the corner, by virtue of the felony murder rule, is charged with homicide. And regardless of, I'm not debating the benefits of the felony murder rule. That's for another time. But a judge might look at that 13-year-old lookout, might look at it differently, than the kid inside who got into an argument, pulled a gun, and shot someone. But they would both be charged with homicide. And that might be, for example, somewhere where it would benefit a judge to go, okay, what's the best for both of those? That was a theoretical, a hypothetical there, but that's one of the reasons we want to see what is genuinely, truly in the best interest. Because I've also seen that as it winds out, if the gunman cuts a plea, and then this person who was outside, who had no idea that there was going to be a gun involved in a robbery, winds up serving a longer time because they got put into that adult system. So the community safety will always be, judges are always going to be looking out for that. That's, or at least in Pennsylvania, that is something that's always in the forefront of their mind, I believe. So this is just a way to let the juvenile judges make that first that first look to decide what's best, rather than an adult judge or an adult criminal court judge who does not have necessarily the familiarity or expertise with juvenile psychology that a juvenile judge might.
Great, thank you very much. In the interest of time, I know that we have 3 minutes before our official ending here. I do have a couple other committee business. So I'll ask if we have any additional questions for Representative Zabel. He was very gracious to provide his contact information, that maybe we reach out to him in that manner to ask any additional questions. So thank you again, Representative. Your experience obviously in this is very much appreciated. And as the chair, I love your timing. So I appreciate it as well. So moving, yes, so thank you very much, sir. Moving just to wrap things up so that we have everybody off on time, I'd like to propose 2 things. One, I would like to propose that we add an additional meeting to our lineup. We had requests for many different speakers. I think we had an incredible set of speakers today. I think we learned a lot. I would love to dig into what they said as a group. So I think that an additional meeting would be very helpful. I don't know, Jamie, if I need a motion for that, or I don't know, is anybody opposed to that? Jamie, help me out.
Yeah, you don't need a motion.
Right.
We can set that up with the next meeting, and I'll be in touch with some upcoming available dates.
Great, thank you, Jamie. So I don't see anybody shaking their head that they don't want to meet again. I think we all understand, and I think that the point was made very well today, that we need more time to discuss this. So we'll add another meeting. The other thing that I'd like to propose, if you're okay with it, I'd love for people to start sending their recommendations in on how we want this to look moving forward. Obviously, we are on a very tight timeline in terms of the report. We know that we have to have that started. So if we had concrete recommendations for our next meeting, ahead of our next meeting, I think that would give us the opportunity to start talking about them, looking at the different perspectives, and then seeing if we could come together with any coercion. Any objectives to that? Objections to that? Nope. So Jamie, do I throw you under the bus, or do I throw my friend Jessica under the bus to receive those, or both of you? Who do I do that to?
I think Jamie and I can work together, so you can send them to either of us, and we are in constant contact.
Great. So if we could, as a group, send any recommendations to Jamie and Jessica, I'll ask that we work together to get those into a coherent document and get that out to the group so that we can have a discussion on those recommendations at our next meeting. With that, it is exactly 3:30. I want to be mindful of time. I know several of you have another commitment that you have to go to. I appreciate everything, all the time that we put forth. I really appreciate all of the recommendations on speakers. I think we had a very good set of speakers. I'm sorry we weren't able to get everybody's recommendations together. We'll talk, or everybody's recommended speakers together. We can talk through that a little bit more as well. Thank you very much. As you know, I'm always available if you need anything. And with that, I'll get a motion to adjourn. Or you can just hang up.
So moved.
Thank you, ma'am.
Sure.